I'm attorney Brendan O'Donnell. In today's video, we're going to take a look at the Pennsylvania Superior Court's May 2024 decision in Frye versus Penn Exploration. That decision from the Pennsylvania Superior Court is a non-precedential decision. That means it doesn't have the force of precedent within Pennsylvania. However, understanding the Pennsylvania Superior Court's treatment of the issues within Frye can assist one in evaluating how a court might deal with oil and gas issues in the future, including some that are related to, but not identical to the ones presented in Frye. On the surface, the issues in Frye seem fairly straightforward. On one hand, the oil and gas owner did not establish that the driller's failure to pay timely shut-in royalties terminated the lease. On the other hand, the driller did not establish that the oil and gas owner breached the lease. So the matter had to go back to the Court of Common Pleas for further development. Case closed? Not necessarily. Of particular note is the Superior Court's treatment of the shut-in royalty issue in Frye. From a historical perspective, some courts have viewed a shut-in royalty payment as the equivalent of production. The shut-in royalty payment is made when oil and gas is not produced from wells that are capable of producing. So, a failure to pay a shut-in royalty payment on time could be the same as a failure to actually produce oil and gas. That could result in the termination of an oil and gas lease. The Frye Court didn't go down that path, however. Instead, it took a look at the language of the shut-in royalty clause in the actual lease at hand. The Superior Court determined that the language in the lease did not say that a failure to timely pay shut-in royalties resulted in lease termination. So, the Superior Court found that the driller's failure to pay shut-in royalties on time didn't terminate the lease. This presents an interesting takeaway message. There are general principles and historical decisions of courts dealing with issues like shut-in royalties. Overarching concepts about why certain provisions exist in oil and gas leases can inform the purpose or intent of the parties to include that in their lease. However, that might not be enough to establish whether a party has complied with the lease or not. Instead, the language of the actual lease and what the lease says about performance or the failure to perform may take precedence over the historical importance or purpose of a given clause in a lease, like a shut-in royalty. If you have an issue about an oil and gas lease or a shut-in royalty clause in an oil and gas lease, my contact information is linked below the video. Also, we have a blog post about the Frye case. That's also linked below the video.